Okay, so I won't say rebuttal time then.
That's right, that's right. Well, just give me a minute so that I can catch up with
Oh, that's fine.
where you are. Let's see here. All right, this is in Ray RP, also known as RA. We've read the briefs and we're ready to proceed.
May it please the court. This is, my name is Dave Gebrock. I'm the attorney for the appellant father, Justin Taylor. I wouldn't make a comment about learning colleague, but anyway, all right. This case, Your Honor, is structurally flawed from the beginning. And our argument has primarily been a due process argument in a brief, but I'm going to try to argue just based upon that. But I'm going to show you how it evolved over a period of time to become a due process issue. 2 days after the birth of his daughter, my client called Children's Services and a hospital, and he was concerned that the mother of the child might be an addict and that he may be the father, but he wasn't sure, but he provided his name and number. The court then went ahead and held an adjudicatory hearing, a dispositional hearing, and a custody hearing without notifying the father. They did a John Doe notification. Also, by the way, it's interesting that the child's name was also changed without the benefit of a motion or any notice being filed. 4 years later, he learns he may be the father, so he does genetic testing. And he turns out he is the father, so he files a 60B motion, which the trial court denied, but this court overruled the court's denial and vacated the decisions that the court had made at that point in time. The Sumner Child Services, and I apologize if I call them Job and Family Services, that's what we call it in Medina, I apologize, filed a new case alleging the lack of relationship and abandonment, and they reinstituted the same arguments, basically, that since 2007, my client hasn't been involved in this child's life, when in reality, that 4-year period of 2007 and 2011, he didn't even know the child was
So
his.
there's nothing in the record that somehow outside of the formalities, he might have known that that was his child.
No, he called and there was a social worker who had his phone number back in 2007, and they knew that. And then that was what, if I remember correctly, that was what this court, part of what they hung their hat on when they overturned the judge's denial of 60B, if I remember correctly. All right. This case came back to the Court of Appeals again, and then back to the court. This time the Court of Appeals affirmed the judgments from the juvenile court. Then the CSB walked a motion for custody to a visiting judge who hadn't heard the case. Now, they knew better than that. And they know that you're not supposed to do that. And also, my client's attorney before me and Judge Teodosio knew that was not supposed to happen. Because my client's previous attorney filed an appeal and Judge Teodosio vacated the order signed by the visiting judge. But the CSEB claimed when they walked the motion that they had engaged in reasonable efforts. Okay, I'm not going to say anything about that. At this point in time, now that we've established that from 2007 to 2011, my client didn't even know he was a father. My client was actively involved in trying to get his relationship established, get the custody of his daughter. At this point in time, you'd think that the CSB would start working with him, start correcting their past, clearing out the underbrush, make it more cooperative. Instead, he runs into a problem where he's having trouble making contact with people. And there was a testimony about the social worker claiming that she wasn't getting his emails, that they were going to junk mail. Conveniently, his were the ones who were going to junk mail. But yet she got his email when he filed, and it was on vacation, there was a robo response, she did get his own email. So we know proof that she is getting his emails. She refused to meet with him on a Saturday. She said she doesn't work on Saturdays. My client works Monday through Friday, so my client was supposed to give up work to meet her on Monday through Friday because she doesn't work on Saturdays. Yet she was able to schedule her time to see Angela, who didn't work full-time, who only worked part-time Monday through Friday.
See her when?
Sometime Monday through Friday, they would schedule days to meet Monday through
So
Friday.
in other words, she didn't do that one on Saturday.
Right, she didn't do that on Saturday, and she was able to work with a woman who only worked part-time, so she didn't miss her time from work to meet Monday through Friday, but it was expected that my client was supposed to give up time from work to meet her Monday through Friday. We're talking about the social worker. Then we have a guardian ad litem who wouldn't respond to emails, who did not visit for a year, did not date his report, and what I really found interesting was that the school was told by CSB not to respond or communicate with my client by emails. Now, I didn't realize the school was the CSB was the in-house counsel for the school, and I'm being a little sarcastic there, but what was their place to tell the school that they can't communicate with my client through emails? My client wants email communication because a letter can be a summary of what people said. Telephone communication could be misunderstood. But when it's in an email, it's obvious, this is what I said, and this is the response I got. And he was, at this point in time, not trusting the agency or not trusting the GAL or the social workers, and he wanted just to be clear who said what and who responded how. He
Did
was
the
told.
agency admit that it told the school not to respond to the father through email?
Yes, that's right.
That was not disputed.
That's correct, that was not disputed. He supposedly, because he failed to go to doctor's appointments, that was another reason why he was not committed to this child. But yet, the testimony was he was not notified of these doctor's appointments, and that's why he didn't go to these appointments. But having said that, let's look at something else that happened. During the period of time when my client's daughter was living with Angela, there was another girl there named Precious who was accused of inappropriate sexual contact with the children that was in that residence. And Precious was removed and went to Don Appy's home. That was the husband of Angela, but they were divorced at this time. My client found out about this when Don Appy told him. CSB didn't tell him that his daughter was in a situation where inappropriate sexual contact had occurred, and didn't tell him that the child had been removed, and they didn't even tell him when the child was brought back to the home, put back in the same environment with his daughter. Don Appy told him. Then it came out later that this same young girl, Precious, tried to poison these children for, I think it was weed killer into like Kool-Aid or orange juice. Nobody got poisoned, thank God. But again, my client wasn't told by CSB, he was told by Mr. Appy. Right. All this, and then the horrible thing my client did, so he's not the father, so he doesn't get custody, is he would not go to counseling, individual counseling. He did not complete the individual counseling that was part of the case plan.
Well,
He did everything else, but he didn't do that.
you said he would not.
Well, he started and wouldn't complete it. I apologize.
Wouldn't or didn't?
Would not and did not. That's the correct answer to that. He started, but he would not complete it, and he did not complete it. His reason that he gave, and CSB and counsel for CSB considered inappropriate, was that he didn't trust them. He wanted that child home, and then once he got that child home, he would put her in whatever counseling. But as long as the child was in the athlete's home, where we had this incidence of sexual inappropriate contact and a potential poisoning, he didn't trust them. And he didn't see any reason why he should be doing this counseling when, as long as they were, as he said, still in danger over there. He wanted that child home with him, and he would get her all the counseling she needed. And he figured as long as she's in that, there's going to be continual perpetuation of the need for counseling. Get her away from that, getting away from enhancing and continuing the situation, he could contain it and eventually deal with it. Okay. My argument is based Due process is flexible and calls for such procedural protections as the situation demands. It's not a technical concept with fixed content undefined by unrelated times, place, and circumstances. It's a fundamental fairness, a requirement whose meaning can be opaque and lofty. Okay. You, as a court, must consider the private interests that are being affected, the risk of erroneous deprivation of safeguards, and the burden of additional safeguards. It's flexible, and it can't be precisely defined.
What is father's living arrangement?
I'm sorry.
What is father's living arrangement?
He has his own place.
Apparently he had a past history of not having stable housing.
Yes, he had different times. One time he was living with his mother, and that was a problem because there was an allegation
Okay,
that.
so the bottom line is he has permanent and
Yes.
appropriate housing now, and
Yes.
that looks like it will continue in the
Yes.
future.
Yes,
Thank you.
thank you. Summit County, in their brief, argued best interest. They talked about the interaction of the child, child's adjustment, parent most likely to honor parenting time. My client testified that if he would be awarded custody of his child, that he'd be more liberal in the time he would provide to Angela than Angela provides to him. Summit County repeatedly relied on the fact that Angela has cared for RP since 2007. But we know from 2007 to 2011, he didn't even know he was the father. So to keep counting on a 4-year period of time which he didn't know his father is at best disingenuous. The reality is, what happened from 2011 to 2015 when we were fighting this case around Christmas time last year? What was happening then? And what was happening is what I've been telling you. CSB keeps using that 2007 to 2011 period of time to expand their argument as to how long this child has adjusted to where she lives and that her interactions. But again, that's specious and unfair because those 4 years do not count because he did not know he was a father. This child knows who his father is, her father is. This child visits. We offered thumb drives which had videos which showed how the visits went when my client had the daughter at his house. We offered that in evidence. The only thing they had against him, because there was no evidence that my client ever abused his child, failed to feed the child, failed to care for the child, failed to provide a place for this child to stay when stable, none of that. The only evidence they have is refusal to engage in individual counseling. That's it. They can't point to anything that made my client an unacceptable parent. And I even argue they do not guarantee a perfect parent, they're just guaranteed an acceptable parent children.
Well, did the agency state any reason why it wanted counseling? You say he refused to go to counseling. So obviously the agency wanted him to go to counseling. What are we going to find in the record about his need for counseling?
I think you're going to find that they're talking about counseling to get to know each other again, reintegrate each other, be more comfortable with each other. They kept bringing up testimony that supposedly the young girl didn't want to spend time with dad. But yet this is after having been, not even knowing dad for 4 years of her life and then living in an environment where it's obviously in opposition to his position. So I'm not surprised that Sean might have expressed she's not interested in spending time with dad.
We have a little under 2 minutes.
But almost done. Apologize. Okay. Other than in the situation that they created, their whole claim is justified what's in the child's best interest. But in reality, what they have done is they have abused my client's due process rights and his fundamental right to raise his own child, and they haven't pointed out, established in any way, shape, or form, other than the fact that he would not engage in individual counseling to justify their position that my client that they should continue to maintain custody of my client's motion should be denied. That's it.
As to the best interest, seem to recall in reading the briefs that there were a couple of professionals that opined that it would be devastating for the child to be taken away from the current home. In addition to that, the one medical professional, I think it's medical, that made the counsel, the GAL also agreed that it would be very devastating for the child to now go with the father.
You're correct. All those officials that opined it based upon old information. None of them had done any recent interviewing with the child investigation. The GAL, in fact, hadn't done anything in a year. Despite my client's repeated opportunities to come out to the house, he refused to do it. He didn't update his report, which is in violation of both of the court's own rules, juvenile court rule, that he's up to date, has to get up to date report. He brought in